Volume 1 of his documents. At page 7, Honorable Speaker, paragraph 20, there is an averment there, Council, that has been made by the governor that in fact there was a holding of the High Court, and this is in reference to Malindi ELRC petition number E006. I don't know if we are together. Council, page 7 of the bundle at paragraph 20. Council, the volume number 1 of the governor's bundle, page 7, for heaven's sake, Honorable Speaker, my time is being wasted by things that I've already said.
Just proceed.
Honorable Speaker, I'm referring to bundle volume 1 of the governor's
Senator
bundle.
Sifuna, you
at page
can only
7.
repeat if I tell you to repeat.
Thank you, Honorable Speaker. Council, you have presented the averments at paragraph 20A as a holding of the court. That in fact, the paragraphs you have superimposed there were a holding of the court. Now, you are a lawyer of great repute, and reading a judgment, you can ascertain what a finding of the court is as opposed to an analysis of the presentations of the parties. Honorable Speaker, the judgment referred to is at page 70 of that same bundle, exhibit number 1. And I want the counsel for the governor to confirm to this House that in fact, the paragraph quoted at 20A is not a finding of the court on the question of what 2/3 means and what should happen when there is a decimal. Honorable Speaker, I will refer you to paragraphs. He has quoted from paragraph 83, which cannot be a holding of the court. And in fact, the holding of the court should be at paragraph 86 of that judgment. Honorable Speaker, my question therefore to him is it proper for you to present an analysis of the case by the learned judge as a finding of the court? Honorable Speaker, that is the question I wanted to put to him.
Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, my comment on this will be limited on what I beg that the House adopts to help this country. This is a very serious matter, and Mr. Speaker, it is already on record that no court can injunct Parliament. So the first PO should collapse. A decision has already been made. My second comment, Mr. Speaker, is on the question of numbers. Kanzo Mutuma, what would you like the governor to prove? It is a scientific fact that 47 divided by 2/3 is 31.3. As you guys say in law, res ipsa loquitur. It proves by itself. What do you want him to prove? It is not possible for a human being, Mr. Speaker, to be a fraction. I want, Mr. Speaker, to urge the Council that because you also have a responsibility to grow the philosophy of impeachments, let us agree that on this one, let us give it to the governor. We give him the fact that a fraction of a human being does not exist. Next time, come with full numbers and we would listen to you. Finally, Mutuma, because you're very experienced in this process, listen to what the Speaker of the National Assembly said about the same thing. The County Assembly of Nyamira said about the same thing. The County Assembly of Kericho about numbers during elections. They have said the same thing. So why do you invite us to disagree with all of them? So as to please you or to allow the proper jurisprudence?
Senator Ledama.
Thank you, Mr. Speaker. Mr. Speaker, I just want some clarity from the Council of the Governor. The Council for the Assembly has presented facts that this matter had already been determined by a court. In their Volume 1, page 131, there's a finding of the court that when it comes to the issue of two-thirds, it is not an issue where you determine the question of a human being being able to be fractioned, but rather a scientific. Are you then, in your submission, questioning, or rather, have you challenged, or has anyone else challenged that finding of the court in the matter of Michael Justin Dunda with the County Assembly of Tana River? So that is a point that I'd like you to clarify, because this is a finding of the court. Number two on that issue is on the finding on the matter to deal with JSC, where the court, according to the facts presented by the Assembly, stated that you round off to the nearest whole number. What would be the nearest whole number in a matter which is 31.3? Is it 31 or is it 32? Thank you, Mr. Speaker.
Senator Fernandez, Senator Samson Chirange.
Mr. Speaker, you need to protect me from the majority leader. Mr. Speaker, I want to agree with my colleagues. Just a quick comment is that in the history of this parliament, no one can injunct parliament. So I think on that aspect of injunction of parliament or court order before the parliament or the Senate, it does not hold water, and therefore I think I would advise the defense team of the governor to stop pursuing that line. Number two, and finally, Mr. Speaker, on the issue of two-thirds, Mr. Speaker, my concern is on Section 33 of the County Governments Act and Article 181 on removal of governor. Mr. Speaker, and in the decision of Raila Odinga versus IEBC in 2013, the Supreme Court pronounced itself that when the process, and I want to extrapolate, when the process has taken off and it is time-bound, as envisaged in that ruling before the Supreme Court, that process is time-bound. So by the fact that you read the charges and the process is ongoing, when you look at rule number 16, rule number 14, and rule number 30 on the removal of a governor, the process is already ongoing and the train has left the station. So, Mr. Speaker, the question should be, if the process has already begun, as per Section 33, with the genesis of Article 181 on removal of the governor, therefore, what happens, Mr. Speaker? I agree that in scientific proof that you cannot have a fraction of a human being. But also, for some of us who are not very good in mathematics, there is also principle of truncation. So, Mr. Speaker, you must balance both so that at the end of the day, we give justice to the county assembly and we give justice to the governor and any other person, including the people of Kericho, Mr. Speaker. So since the train has left the station, let us go ahead and listen to the merits and demerits of the case, and then we determine. I submit, Mr. Speaker.
Senator Kajwang.
Mr. Speaker, the issue of limits of judicial authority on independent institutions has been settled. And I think we have seen some precedents that have been presented to us. Secondly, we need to make a distinction between procedural fairness and procedural technicality. Procedural fairness demands that the governor for Kericho has been accused of gross misconduct, and all sorts of allegations have been made against him. This is his opportunity to defend himself against those allegations. There should be procedural fairness as required in our Constitution. The other aspect is procedural technicality. And Mr. Speaker, you do recall that if we were to be obsessed with procedural technicality, in 1992 it is John Harun Mwau who would have been the president of Kenya, because he went to court and said he's the only one who presented his petition in a foolscap rather than on an A4 paper. Mr. Speaker, the ruling that has been referred to by both parties, we are getting different interpretation.
On this matter, we should not go with Rule 30. Rule 30 empowers the Speaker to make a decision. Mr. Speaker, I want to encourage, the way we did in the case of Nairobi Governor Sonko, there were affidavits that were sworn by MCAs that discredited the outcome of the vote. The Speaker ruled that let's allow all parties to prosecute their case, and then the senators sitting as a jury would make a decision on the ultimate day of voting. I would propose and I would urge, Mr. Speaker, that we do not refer to Rule number 30, but allow the House to proceed and ensure that there is procedural fairness in the matter of Kericho.
Senator Kathuri.
Thank you, Honorable Speaker, for this chance of the 2 minutes also to make a comment on this very, very important matter. And Mr. Speaker, as we are here, many Kenyans are watching at us. They are glued on their TVs because, you know, many Kenyans are now sensitive on devolution, sensitive on governance, and all these things. So, Mr. Speaker, the PO number 1 is actually dispensed of naturally. So the PO number 2, Mr. Speaker, besides, because that 1.3, the High Court pronounced itself that you go to the nearest whole number. When you go to the nearest whole number, you run at that one, Mr. Speaker. The other argument is about now the threshold that has been put in Kericho County when they were electing the Speaker of the County Assembly. So, Mr. Speaker, because this matter is about mathematics, so what I would request, as also other colleagues are putting it, Mr. Speaker, we would like to hear these cases. We give the Kericho County Assembly and the Kericho County Governor time to prosecute their matter before this Senate, Mr. Speaker. Because if we determine this matter in any other way, rather than listening to the parties, then we will not be giving justice to the good people of Kericho and the country at large, Mr. Speaker. So Senate will be a house that cannot be able to protect the devolution, Mr. Speaker. So in my submission, I wish that we are able to listen to both sides, and then we are judges. This is a High Court sitting, Mr. Speaker. We will be able to make our determination in one or the other, Mr. Speaker. Thank you very much.
Senator Wambua.
I thank you, Mr. Speaker. Mr. Speaker, two things. One, I don't know why my colleague, my friend, Senator Alwale would want to pick and choose on court rulings. A precedent has been set in the court, and he has quoted it, on the matter of separation of powers, that no court can injunct a parliament in its deliberative roles. And so PO number 1, everybody agrees it falls on its face. Speaker, then PO number 2. You know, what the lawyers on both sides are asking these judges here to do is a very complicated matter. It's a matter of determining a fraction of a human being. What is 0.3 of a human being? Is it still the head? Is it what is it? But the Speaker, again, the courts have pronounced themselves on that matter. And in the case of Tana River, they have said that in a matter like this, then you round off to the nearest whole number, which is 31. Mr. Speaker, there are substantive matters for determination in this motion that this House needs to be engaged in. And you ask me, Mr. Speaker, as Senator Cherargei has said, the train has already left the station. We are already in motion. Let us hear this case. Let's make a determination one way or the other. Mr. Speaker, I submit.
Senator Aaron Cheriot.
Thank you, Mr. Speaker. Mr. Speaker, the people of Kericho have quarreled, and we've come before this House to seek for justice. And we pray for nothing less than justice in the interest of the people of Kericho. I want to make 2 quick observations, Mr. Speaker. One is unanimous by what colleagues have said, that PO number 1 has been determined by not only by Parliament itself, by none other than the Supreme Court of the Republic of Kenya in Wambora 1, 2015, Mr. Speaker. where it has been firmly established on what you do with a parliamentary process, either in Parliament or at the County Assembly, once an exercise has commenced. Therefore, on that count, Mr. Speaker, I plead that the Council for Governor notices and appreciates that particular issue. Second and most important, Mr. Speaker, is on this issue, and I wish my good friend Senator Boni Halwale listens keenly to this. Mr. Speaker, there is what you call the hierarchy of law, where the Constitution reigns supreme. It sits at the top. And when a matter is not sufficiently addressed in the Constitution, you look for it in statute or legislation that we have passed here. Where there is none, Mr. Speaker, what follows after that is already established case law. Mr. Speaker, the Speaker of the County Assembly of Kericho, in his affidavit, and it is hereby presented in volume 8 of the documents from the Assembly, cited court decisions that have been made on this particular issue. Therefore, Mr. Speaker, I don't know on what basis you would want to fault the Assembly, because I have listened to Council for Governor and there is no citation whatsoever on their part other than application of mathematics and this theory that we want to be told that there is no half or quarter of a human being. I thought, Mr. Speaker, that being a house of procedure, we would establish what is a practice that has been established in our courts of law. Mr. Speaker, you know, what I find to be extremely curious, though, is a very dangerous invitation that the Council for Governor is sending out to you. I listened to him, Mr. Speaker, and he wants to lead you to make a decision that has never been made by any other speaker in this House, Mr. Speaker, where he wants you to make a determination on appeal and dismiss this case altogether.
Now, have a seat. Now, honorable senators, it is now 4 minutes past 1. We can only, during a morning session, prosecute business up to 1 p.m. And therefore, allow me to invoke Standing Order 34, 2A, to extend the time for 15 minutes. Thereafter, we shall rise for a break. We'll come back at 2:30 and prosecute this matter because it is of such a fundamental nature. I'll give you 1 minute to conclude.
Mr. Speaker, you are being invited to very dangerous path. Previously, before this House,